the remaining portion of the previous video will found here. So, as regarding the distinction between liquidated damages and penalty regarding amount, in case of liquidated damages, it is always equal to loss, and regarding penalty, it is more to the loss suffered as it was fixed by the court of law. And regarding the very distinction, in case of right of to move to court, in case of liquidated damages, there has no right to reduce any amount as it is estimated in the very contract. But regarding penalty, there has been a right to either reduce if it is unreasonable. So these are the very differences we found regarding liquidated damages and penalty. And regarding actual breach and anticipatory breach, that we can discuss with an illustration. And that illustration, suppose a group of dancers booked an theater for the very performance of the dance festival, and on the very day of actual performance of the dance festival, the theater refused to let them, and that is otherwise called actual breach of contract. But if that owner of the theater would have refused to the dance group either before 1 day or 2 day or 3 day before the very performance of the dance in his theater, then it would fall under anticipatory breach. So these are the very objectives and differences we found between actual breach and anticipatory breach. Now, in our next questions that we will discuss regarding the questions that we have settled, and that is regarding law of torts. So, the first question, define tort. There is a law of tort but not of torts. Discuss and distinguish between tort and crime. And question number 2, elucidate the term voluntary non-fit injuria with the limitation of the scope of the doctrine. Distinguish between act of God and inevitable accident. Then discuss the very principle damnum sine injuria and injuria sine damno with the help of decided cases. And question number 4, which deal with the maxim ubi jas ibi remedium, elucidate with the help of appropriate illustration. And question number 5, every injury is a tort unless justified. No injury is a tort unless it falls within the specified category of any accepted tort. Critically examine the schools of thought by Professor Winfield and Professor Salmon. And question number 6, law takes no cognizance of carelessness where there is no duty to take care. Discuss. And question number 7, examine the exception to tortious liability. And question number 8, discuss the very rules of reliance versus pleasure with exception to the rule. Question number 9, explain in the course of employment with illustration. And question number 10, what are the different defenses available against tortious liability? And question number 11, discuss the changing dimensions of rule of strict liability. So, in that connection, we have to discuss first of all what is the very term. Tort means. So, the very word tort is a French term and it was derived from a Latin term that is tortum, and in English it is otherwise called wrong. And when we discuss regarding the very position of tort in England, ubi remedium ibi jos, which means where there was no right, there was no right, as it was a complete procedural law that was followed in England for a complete 500 years, even after the development of tort in France. And the very maxim ubi jos ibi remedium developed in England, as it means where there is right, there is remedy. Exactly, this is the French version of tort. And according to Salmond, it is a civil wrong and it is a breach of duty which consists on liquidated damages. And according to Professor Winfield, it is a breach of duty which is already fixed by law, and it is a kind of general duty, and it consists on liquidated damages such as we found in the very maxim right in rem, that is a particular kind of violation of right in general of the public, and that is the subject matter of tort, while in right in personam, that is particularly we found in contract, as it is between specified parties into the contract, and while tort is a kind of violation of private or civil rights. And regarding crime, we found there is infringement or violation of public right affecting the public in general. But regarding tort, it is a violation or infringement of a private individual civil right. And regarding that of relating to commission of wrongful act, we'll discuss the very maxim injuria sine damno, which means injury to person or to property. So, regarding injury to person, it falls under defamation, and when it is injury to property, it falls under to trespass into land or trespass into good. And in that connection, we could discuss one leading case, and that is Ashby versus White of 1703, where the plaintiff was refused to vote, right to vote by the returning officer. So there was an infringement and violation of the statutory rights of the plaintiff to exercise his franchise. So also in another case, that is Bhim Singh versus State of Jammu Kashmir in 1986, Bhim Singh was an ex-MLA of Jammu Kashmir High Court, was detained from attending the assembly session. So there was the infringement of his fundamental rights and rights as an MLA to attend the sessions of the assembly. So there is the infringement and violation of statutory rights. So the Supreme Court awarded a compensation of rupees 50,000 to Bhim Singh, as there is a violation of statutory right of the petitioner or the plaintiff. And in another leading case that is relating to Ashrafi Lal versus Municipal Board, Agra, there was one defect that was found by the plaintiff. There was an omission of his name from the electoral roll for which he could not exercise his franchise, so that was a violation or infringement of the statutory rights of the plaintiff. So, in our next video, we'll discuss regarding the maxim damnum sine injuria, which exactly means damage without injury.